Jennifer Spalletta, followed by Jean Salesi.
Thank you. First of all, I want to thank staff and the board members for working very hard this year to try and get additional information and better information than we had last year, and for encouraging the regulated water community to do its part through voluntary agreements. And I think we've made a lot of progress this year. I know I've had some very good conversations, not just with the people in this room, but with other people associated with the export projects and the contractors that we hadn't had before. And I think they've been really, really good at moving the ball forward on a lot of difficult factual and legal issues that we can narrow, and I think we all agree need to be resolved. Unfortunately, the more we talk and the more we learn, and even through the process of gathering better data about water availability, I think the more we realize that when you get down to the nitty-gritty at any individual point of diversion, the risk of being wrong with broad brush analysis is very, very high. And that's why, regardless of these big legal issues that we know we need to resolve, we also know they won't be resolved this week, and they probably won't be resolved this summer. And that's why many of us in the Delta who have clients who are sitting here biting their nails, wondering if they're going to plant something and cultivate it for 3 months only to receive a curtailment order, have said, can we offer something voluntarily that saves water, helps us all get through the summer collectively, moves the ball forward without waiving our rights on these bigger legal issues. And that is what we've proposed as this 25% voluntary program. And we've worked with Michael George, obviously, and Tom Howard to put kind of the meat on what the program would look like. But essentially, it would be farmers who say, okay, I'm still at a point in my cropping planning for the summer where I can make adjustments. I can either do some water conservation here, I can choose a different crop, or I can fallow certain land and achieve a 25% reduction. We'll keep track of it, we'll document it, we'll make sure that it can be verified. We may actually learn something about the way the Delta works for those that participate in the program. You, in exchange, will get 4 months of 25% reduction, which is a lot of water if we're talking about the system. And they, in exchange, of course, receive some regulatory certainty that they can irrigate their other acreage as they have been and get through the summer from a business perspective. So it's really a practical solution. It's a voluntary program, obviously. We hope we get a lot of growers to sign up. But it's a practical solution. It's an on-the-ground practical solution to get people through the summer, achieve water savings, which is important to the system, and save this dialogue and these important legal issues to be resolved, but to a time where they can be resolved properly.
It's interesting, and again, not an opinion yet, but interesting to contemplate. We are in this funny is not the right word, we are in this challenging, I think the word unprecedented has been used a lot, and just recently situation, both hydrologically, but also in terms of actually exercising the water rights system to an extent it has not been exercised before. And so the challenge is on all sorts of fronts. So it's interesting to think interestingly about it and look at other options. But I have a specific question that's sort of prompted by Mr. Nomalini's point, which is one of the things, at least for me, that I'd like to see is that we do resolve some of these issues that have been hanging around. Because my perspective, just dancing in and out of it over the decades, is that there are very strongly held views about the law, and other things, even the hydrology, about the law, let alone what's right and wrong. And those same arguments have gone on for decades without helping us resolve anything. And it strikes me that there's a moment where when I left, people seemed very comfortable in their rhetorical certainty, and they'd take their chances on what might happen out in the world, and that seemed to be a place of comfort. What I'm seeing in this crisis is people saying, let's resolve some of these things finally and move on. But I guess I'd like us to resolve them in a way. One thing I'd be concerned about is buying time and then punting. So in
we don't want to do that.
There has been a strategy for how to lay out, or maybe there's 10, maybe there's 20, maybe there's 7 key issues that need to be resolved. And I'm hoping certainly with the assistance of our Delta Water Master and his acumen and energy on this, to be able to tee up those issues for discussion in the nearer future rather than the later future. Is that a part? That's a
I
part
would
of your
like it to be
conversation?
today, frankly.
Okay.
I wish that
Like that
I wish this was
spirit.
an evidentiary hearing and that I could have asked questions of the people who put the charts up on your screen today. I mean, frankly, we have to get to the bottom of it because there's a lot of people who put up information, but we've never had the opportunity to ask each other the hard questions about those graphs and really get down to the nitty-gritty of the spreadsheet. I mean, I heard what Terry said about missing 35% of the stored water, and we need to get to the bottom of that. The projects have to be able to operate and account for their stored water, and if they can't account for it now, there's a problem. We need to understand it. So the way I view this voluntary program and any voluntary program that you would enter into to get through this year is it is just that. It is an emergency agreement to get operations through this year that operates on a parallel track with resolving these tough issues. And they really are two different things. One is operations, making a difference on the ground to get us through the year. And then the second is rolling up our sleeves and digging in on the tough legal and factual issues. We should be doing both. We should be doing both at the same time. The reason that we like these practical voluntary programs is there are literally hundreds of individual farmers who are having a very hard time this year making basic decisions. And I have a fear that if you roll out a curtailment in the middle of the summer, that the compliance with that curtailment will be sparse. And frankly, that's not good for the system. It's not good for their mental health. It's not good for the economy of the area, and it doesn't achieve your goal. It may help us resolve the legal issues, but it doesn't actually do what we need to do, which is save water and make the system work better. So I think what we're offering with this program is an opportunity to do both, to actually do some water savings and allow these people to operate in a way that makes some business sense. And at the same time, let's dig in on these legal and factual issues and get to the bottom of them one way or the other. Thank you.
Question, Tam?
Yeah, actually, I do have a few questions. Actually, the proposal is very intriguing. So just a couple of questions just to clarify in my mind. I'm sure we'll get the details later on, but as far as what you were thinking, a voluntary 25% in, as I understand it, either reduction in diversion or 25% fallowing of land that would normally be put into production in the critical 3 months. So with respect to the first one, a 25% reduction in diversion, are you thinking that would be 25% less? I think you're talking about a 2013 baseline, so that would be reduction from actual diversion or reduction from the water rights of diversion?
Well, I don't think there'll be an impact on water rights with just 1 year's activity, but there will be an impact on how much water is actually taken out of the river. Yes.
No. I meant when you're doing the calculation of the 25%.
25% of what?
Of
their
what?
riparian.
Yes.
Right.
Perhaps I can answer because we're the ones that are actually writing it up, and I had discussions with staff about that issue, and it seemed to me that what we do is this year in the information order, we asked the 90% largest diverters to tell us what they intended to use this year. And so we have, for a large fraction of the diverters in the Central Valley, an estimate that they provided us saying, here's what we intend to use. We also have some of the data of 2013 use, and we will certainly have more as these statements roll in over the years. So we'll ask the parties, if you want the 25% reduction, you should have two numbers available to you. You should have what you already told us you were going to do last year, that you were going to do this year, as you were projecting this year's diversions. And you have what you did in 2013. Take the lower of those two and take off 25%. That's what the form will say.
And that would be a major problem if that's what the form said. Because the projected numbers for this year in many cases already accounted for conservation measures that were being implemented by the farmers. So that, of course, would be very unfair. But if we're talking about a 2013 baseline,
That's what I assumed
it's a
it was
very
gonna be.
basic concept. If you had a 100-acre field that was irrigated in alfalfa and they put on 5 acre-feet of water during the summer month period, and since that time they have invested in drip irrigation and they are planting a shorter crop, maybe cucumbers for 60 days on drip, there's going to be obviously a substantial difference in the amount of water that's diverted and used on that property, probably more than 25% savings on that particular property. So we would have to compare apples to apples with how they computed their diversions and use in 2013 with how they compute their diversions and use in 2015. If there's measurement devices in place, that's relatively easy. Otherwise, we have to use the same methodology, to make it an apples to apples comparison.
You would have to have some kind of real number to base it on.
Correct.
And
Yeah, I don't want to talk about that. Taking the lower, that doesn't seem right to me. I'm sorry, Tom. That doesn't seem fair. I'm not saying that it's 2013, 2014, but I'm not getting it. So.
Yeah, that was the first I'd heard of that. We previously had talked about doing a baseline of 2013 or 2014, certainly not using the projections from 2015 as a baseline, because many of those projections, of course, did include plans, for fallowing or reductions in use already.
It's complicated.
Yeah, I would think just stick with it. I really appreciate your energy and all of you that are working on this. So stick with it, and hopefully something can be worked out. I have a question for staff. So slide 25.
actually, if I could finish my question
sorry.
Before
Yep,
you move
sorry.
off the topic. So I think it probably can be understood without saying, but just so I have it perfectly cleared. So the water savings through fallowing or reduced diversions would be water then that would not be available for transfer or other uses.
The water will basically remain in the stream. Okay. Now,
Good.
I will
Good.
tell you.
The key is it's got to be real water, or
It
doesn't
has
make
to be real water, absolutely. And I wouldn't propose this program, and I know that my landowners wouldn't propose it unless it was real water. It just doesn't make sense. The other thing.
And then I guess, go ahead.
No, I was going to say, though, but this type of program is going to teach us a lot about the effect of taking these activities in the Delta, which I think could actually be a springboard for other programs that maybe could lead to ideas about how to change stream flow or how to effectuate transfers, using the Delta. And so it's an opportunity to learn for the future as well.
And my last question is to help me understand this in context. And so will you just say your growers, how many are we talking about? How much water are we talking about potentially?
Yep.
Do you have a rough estimate?
I have absolutely no idea. I will tell you that, I personally, on a weekly basis, talk to growers who farm about 40,000 acres in the Delta, and they're all very interested in the program. There are other people who have expressed a strong interest who represent probably a like amount of acres. Between the South and Central Delta, there are about 300,000 acres. Do I think that all of them will sign up for this program? Probably not. It's just frankly too late to do that kind of outreach and accomplish that result. But I do think that we'll get a critical number to sign up, and that's real water. That's a lot of water. Even if we had 10 or 15,000 acres sign up, it's still real water. So I think that the program will achieve water savings if we get it moving so we can get people signed up. It's really a matter, though, of days here in getting it moving because farmers are still making some planting decisions for the summer, and they need to be able to figure out what they're doing so that we can achieve some savings. Thank you all very much.
Well, hang on just one second, because the point that I was going to make is just the ability to glean additional information as a result of this, the whole issue of consumptive use in the Delta and that sort of thing. And looking at what staff had suggested on slide 25 as far as going forward with curtailment inspections, at the top of the list is non-responsive to curtailment certification form. So assuming that the growers that would be participating in this would have some sort of certification form on file. Not that they would be ignored, but the focus would really be in other areas, allowing staff to move forward perhaps in some of these issues that we're trying to get to the bottom of. So it's just a way to narrow down the focus.
As I understand, the focus would shift to obtaining the information that the fallowing had occurred, that the reductions had occurred, so that there would be a shift in focus.
The monitoring.
All right, thank you.
Chair Marcus, just
Yeah.
for clarification, I've been telling staff that we have to make a decision on this and get it out by Friday because it's supposed to start on June 1st. And, every day that we wait, as the previous speaker had indicated, people are making their decisions. And so this isn't something that I think is going to age well, and we need to make a decision. And
Right, and then you need to put in front of us individually, since it won't be tonight, what the parameters are, and let us give you feedback.
Sure.
Between now and then. I mean,
Yeah,
we've
of
had
course,
a
I've sent you
general
a couple of things
conversation,
already,
but we just got into a set of details that we need to understand if you want our feedback. Otherwise, someone's going to challenge it,
Sure.
and then it will come back. So I think the onus is on you all collectively to lay it out, give us the details, pros and cons, where the warts are, et cetera. I mean, in general concept, I'll say I'm intrigued by it, given that we're not going to resolve everything. But I do want to hear what the blowback will be or the cons. And we've had a general conversation, but the devil's in the details. So, I'll look forward to seeing it.
Yeah, no, it's fine. I mean, I don't mind discussing it a little bit. And my impressions of it are, there's a choice we need to make about the baseline. And maybe one of the, in thinking out loud, if we want to really accomplish real water savings in this context, it's tempting to use 2013 because we've used that for our urban water conservation targets. But I realize, in terms of realizing real water savings in an emergency situation, what is an appropriate baseline? How do we, will we make a measurable difference comparing to what was predicted a few months back and reported, or comparing to 2014? These are the questions.
The question.
In terms of what's going to get us an outcome in terms of, helping fish and wildlife, making more water available to senior water right holders, and those questions. So, I'm at a point where, I really realize the time-sensitive nature of this, and I'm willing to, take on some risk in setting up kind of a system to encourage this voluntary approach. In terms of, when I say that, I mean knowing that I don't have all the answers to those questions, but there's a timeliness to this. So I think on the one hand, 2013, there's compelling reasons to use that for consistency in a statewide story about conservation relative to a couple of years back. And then, and then I asked staff, is that giving too much credit for things that have happened already, and it won't make a significant difference this year in terms of making critical acre feet of water available?
Well,
So
isn't part of it based on calculations of the supply-demand curves that John O'Hagan is working on? I mean, whether it's 25% or whatever the number is, the idea is to get roughly equivalent savings as what would have occurred with a correlative reduction for riparians.
That is information that is used to inform the question of whether it is reasonable to offer a 25% reduction, but it is not necessarily the sole determining factor. I can't guarantee, because, for example, if we did a reduction, and it could very possibly be we would send out curtailment notices in August or even the beginning of September. for riparians, and it might be a much larger reduction. And so, you're looking at, well, you have 4 months now of a reduction as opposed to, maybe the 2 months you'd have if you sent out a riparian notice. And so if you're somewhere in the area of 25 to 50% of the supply-demand curves, then, it would seem as though this is a reasonable thing to offer for the purpose of ensuring that we, providing assurances to people and the assurance that we actually see some real water.
But I guess what I'm saying is you could compare that number to the various baselines
Of course, we're
that you're
looking at
talking
that's
about.
exactly what I was doing, yes.
Well, yeah, I'm like Board Member Diadamo. I think this is very healthy exercise, but there's a time sensitivity to it. And I'm comfortable moving forward, not having all the answers, but knowing if you do a reasonably quick analysis of water savings, that it's worthwhile in building the team effort and then keeping an eye on it. The monitoring will be important. So I'm very favorable to moving forward with something this week.
Thank you. Ms. Leslie, followed by Jennifer Buckman.
Good evening, board members. Jeannie Zalezi, representing Patterson Irrigation District and Banna-Carbona Irrigation District. And I just want to mention those are both pre-1914 water right holders on the San Joaquin River. We have also been talking to the Delta Water Master and your staff about a potential voluntary curtailment agreement. We'd very much like to explore that. We're waiting for numbers because we feel very strongly that a voluntary curtailment is much preferred to the chaos and the litigation that would follow a mandatory curtailment. And I agree with Ms. Spalletta that we'd like to have something voluntary for this year while we still pursue getting answers to those legal questions that must be answered for us to continue in this venue. I just wanted to go through a few of the reasons why we don't believe that pre-14 curtailments across the board are appropriate at this time or legal at this time, just some things for you to think about. Regarding data, I think everyone has done it that's come up here. We really do want to commend your staff. They have taken the information we've provided and they have just made extraordinary efforts in trying to take those comments into consideration and come up with the best data they can come up with. It's been a Herculean effort and they've done a great job. The problem is in the San Joaquin River system, there are just no answers to some of the anomalies that we're finding. Even the top experts on the San Joaquin system who usually have all the answers don't have those answers this time. For example, just looking at the 7-day running average from last week, working with the experts on the San Joaquin River, we went through, we looked at all the gauges, we looked at all the reservoir releases, and we looked at actual diversions from the river that were taking place, came up with the number that we expected to see at Vernalis. Well, that wasn't the number that showed up. The number at Vernalis was 200 CFS higher than that. And nobody, including the expert on the San Joaquin River, can explain why that is the case at this point. So there are things that simply cannot be answered in the San Joaquin River. And when you enforce a curtailment against a water right holder, you have the burden to demonstrate that no water is available. And when we don't have the answers as to what water is there and where it comes from, we can't make those conclusions. Regarding the right to divert, again, imposing curtailments based on an assumption that a senior water right holder is being injured somewhere downstream is simply not authorized and not within the state board's power, frankly. A junior water right appropriator in California has the right to continue to divert as long as there is water at their facility and a senior water right holder is not being significantly injured. It's not enough to say, it's not enough for the state water project contractors to get up in here and say, we are losing 30% of our water. Curtail everyone. It just doesn't work that way. They have some burden of showing where that 30% is going. They have no idea. frankly, that's why we need data. That's why we need some questions answered. And as Dante mentioned, curtailments are based upon site-specific and time-specific determinations, and they also depend upon specific priority at a specific location. We simply don't have those facts. We haven't even attempted to get those facts, and we haven't had a factual hearing. We haven't had an evidentiary hearing to glean those. Just as an example, if you have a senior water right holder in the Delta who has a certain water right for a CFS diversion, and it's for irrigation, they don't divert water 30 days out of the month. They divert water a few days to irrigate, and then a few days later in the month to irrigate. When they are not irrigating, the junior water right holder has the opportunity to take that very same water legally. Your staff's information is based on a 30-day use of that water that's been reported. That's not correct. That's not the way junior and senior water rights work. If it was, it would never work. Even in the wet years, we couldn't get that done. It's because we have seniors turning on and off and juniors using that this whole system we have with the over appropriations that you keep hearing about, that's how it works. Another issue, when you're talking about my clients, pre-14 water right holders in the San Joaquin River, being curtailed to protect more senior, quote-unquote, pre-1914 water right users in the Delta, you have a real difficulty because those pre-14 water right users in the Delta are simply claimants. No one has determined whether or not they have valid pre-14 water rights. They very well may, but no one has determined that. So to curtail upstream pre-14s in favor of downstream more senior pre-14s who have not established their rights is simply not equitable, it's not legal, and of course it will be challenged.
So I follow the logic. So that basically would be an argument that we can't do curtailments because we haven't adjudicated the whole system.
No, you have no idea if someone has a valid right. When you're dealing with post-14s, you have a
But
permit
you're saying we
in your
could never
hand.
curtail seniors because we haven't adjudicated it fully the way other Western states have. Or in some cases we have, in some cases perhaps we have.
If you have
in a
determined a
conflict, but I'm trying
pre-14.
to understand how what you're saying doesn't mean we just can't do it at all ever
Well,
until we
That
adjudicate
would
the
be
whole
my
system.
legal conclusion.
That would be your
because
conclusion. I
that-
just want
that
to make
was
sure
my
I'm
next
understanding
point,
what you're saying. Okay.
that you have no authority over pre-14s. And that's one of the reasons, is that you don't have a permit that you can look to and say, this pre-14 has a right to take this water at this time. I mean, the courts have very clearly said, very recently, that you do have the authority to determine if a pre-14 is valid. They have said that you have to do that in order to determine if they're legally taking water. But the court also said you can't go beyond that. You can't regulate that water right. And once you determine a pre-14's right vis-a-vis another pre-14, you're regulating. Once you tell that pre-14, okay, you have a valid right, but you have to stop taking it because other water right holders need the water, you're regulating. And I would ask you to ask the hard questions of your staff because we know that your legal counsel is telling you something different, that you do have that authority. And obviously, we will get the answer to that because, you know, if we have broad brush curtailments, we will bring that up and have the legal answer.
Right, I'm assuming that one's on the list.
It is. But
But I'm going to
that's-
want to see the
yeah,
list.
And that's where
frankly.
we get to it because how can you curtail me as a pre-14 when I have data? I have a posted notice from 1911 that shows I have a valid right to divert, and someone else just says, oh, I have a pre-14 right with no proof and no determination or fact finding by this board that that's the case.
So what you're saying is that we don't have jurisdiction over pre's, and that in addition that we need to wait until we get a complaint. Someone has to be injured.
Well, as to
Has to be a showing.
absolutely, that is the law as well. You could, if you could determine without a complaint that there's an injury, obviously you can proceed that way. But again, the courts have been very specific, and the California Supreme Court has stated that a threat of harm, which is what we are hearing staff telling us, that we are curtailing in order to protect, John O'Hagan told us, well, there's a threat that these senior water right holders will be injured because you're taking their water. The California Supreme Court has said a threat is not enough. You have to prove that the senior water right holder has actually been substantially injured or materially injured. So if you're just taking water that they weren't going to divert that day, you're legally entitled to it. If you've inconvenienced them, you're entitled to it. If we've taken, 1 acre-foot from the projects, that's not a substantial injury. And they cannot show what water we're taking, if any, that we're not entitled to. So yes, our point is that you simply don't have the site-specific information that's needed to do this. And again, as we've said it before, it's also the due process issue. We're getting double speak, very frankly, from your staff. We receive in the mail, the post-14s received a letter that said, you are immediately to cease diverting, and within 7 days you will file under penalty of perjury a certification that you have stopped diverting. But it's just a notice, and it's not enforceable. We can't have it both ways. It's either a binding notice to cease diverting, or it's just a letter saying, might not be enough water for you, better consider what you do, or we'll come after you. What you sent out is a notice. It is an order to stop diverting. And you cannot do that without a due process hearing. You can't do that without an evidentiary hearing. And that's why your staff is not calling it an order. It's just a notice. Because as you well know, you can't have a binding order affecting your property rights without some kind of due process, without a hearing, right to be heard, evidence, which we've had none of. We simply have staff based upon a graph that we haven't been able to cross-examine or correctly verify, saying someone might be injured in the future, you have to stop diverting. It simply doesn't work, which is why we are asking, let's see if we can work out something voluntary and still pursue these legal issues to get them answered, or let's take a different approach and wait until we have complaints, and you can do that site-specific determination through a hearing, and then we'll get our answers and we'll know who needs to be curtailed and who doesn't need to be. But we hope to get some numbers from your staff, and hopefully we can work out some voluntary curtailment so that we don't have the chaos that follows, and we can come up with some kind of orderly way to get these questions answered. I know that Mr. George has been working very hard on that to try to get some of these questions answered in a orderly way rather than the chaos that would result. So I do thank your staff for its efforts. Thank you.
Buckman?
I just wish my housekeeper vacuumed that well.
Can you hear that? It's like someone's vacuuming in the hallway behind us for 15 minutes. I don't know. Sorry. We are listening. It's just.
And for some reason, I'm always last at these things. I'm Jennifer Buckman. I'm here on behalf of the Friant Water Authority. And I just wanted to clear up, I don't want to, it's late, and I don't want to repeat any of the comments and be repetitive of comments that have already been made for us by others, but I did want to clear up the comment in reference to Arvin Edison Water Storage District, which is a Friant division contractor and a member of the Friant Water Authority. They are not transferring 150,000 acre-feet of CVP water this year. The Friant division contractors, as this board is painfully aware, got a zero allocation this year like we got last year. We didn't, as a whole division, we didn't get 150,000 acre-feet of water either this year or last year or the 2 years in combination. So our hydrology this year is even more challenging than it was last year because the local streams have basically very, very little supply to augment. So the folks in our division that have other sources of supply are in an even worse situation this year than they were last year. As a result of that, we've put together a complicated package of exchanges and transfers in order to develop a water supply for the Friant division contractors. And as you all know from some of the prior workshops and such we've had on the TUCPs, within our service area, we have thousands of families who are still out of water 10, 12 months later after their wells ran out. It's primarily impacting low-income families, folks who can't afford to drill the well deeper or move. And in response to the comment earlier that there are no endangered farmers, well, there are in our area, in Terabella and Lindsay and Strathmore and Orange Cove. I know plenty of endangered farmers. A lot of our guys, our growers, have been on the same land for multiple generations, and right now their lives and livelihoods are on the line. We've got 15,000 small family farms within the Bryant Division. The average farm size is less than 200 acres. These aren't guys that can weather a long multi-year drought like that. As I've mentioned to the board before, within the Bryant Division is a little bit unique in the fact that we are a conjunctive use system planned that way under the California Water Plan and operated that way, which means that our M&I contractors, those who have municipal and industrial needs within the Bryant Division, are served by a Class 1 contract, not a specific M&I contract. So it's critically important for us to develop some Class 1 supply for those contractors this year, because we've got 6 cities, including the city of Fresno, that are Bryant contractors and need that water. A lot of people worked very, very hard to get what is essentially a replacement of the Class 1 supply we would otherwise get. And it's not just Arvin Edison. We have other Bryant Division contractors who worked on that. Delano Early Mart and Current Larry were both involved in the transactions, as were a number of our neighbors. The exchange contractors and Westlands Water District was very helpful to us in making some water, taking some water out of San Luis so that we could avoid a low point problem and make the water available behind Millerton. We were able to back it up through a multi-party exchange. It's a really complicated package of transactions that we put together. And that's why it may be confusing to folks who just read, oh, there's 150,000 acre feet of water that's going to change hands at some point. But that's not this year, and it's not CVP supply. We're developing a minimal supply for the Bryant Division contractors. We're getting a total of less than 30,000 acre feet for the entire division. So I also want to echo the comments that a bunch of other folks have made about how the state board staff has been really helpful this year, and we appreciate that. It's a much more iterative process this year than last, and we're very thankful for the discussions we've been able to have with Kathy and Michael and a bunch of the other folks.
Thank you very much.